Welcome to the premiere episode of Honigman's podcast, Coffee and Counsel. I'm Adam Rothstein, co-chair of the real estate department here at Honigman. Honigman is a business law firm with over 300 attorneys, headquartered in Detroit and with offices throughout Michigan and in Chicago. With me today are two of my esteemed colleagues from our real estate loan workout group, Larry Woodard from our Chicago office and Joel Krugel, the vice chair of the real estate department. Today, we're going to dive into a very pertinent topic for many commercial real estate owners. We're going to discuss Cmbs loan defaults and how best to approach your special servicer. Quick legal disclaimer, this podcast shall not be deemed to be legal advice, should not be relied upon as legal advice, and should not create any attorney-client relationship with any listener and Honigman LLP. But now that we have that out of the way, let's dive into the first question. So first, a little background about Cmbs loans. Bear in mind a couple of key features of Cmbs loans. First, the loan is non-recourse to the borrower, meaning the lender's sole remedy is to take the property. That is, of course, subject to certain carve-outs which come into play as the threat of violation of certain covenants can bring carve-out liability to the borrower and can bring leverage for a servicer. Second thing, the originating lender, the one with whom our borrower clients might have a relationship, is completely out of the picture. They've sold the loan, they made the loan and then sold the loan, and they're dealing with all new people. Third, the servicer that takes the spot of the lender is bound to follow something known as the pooling and servicing agreement. And we'll discuss that a little bit later. Fourth, changes to the loan generally require special servicer approval. And the special servicers have certain incentives that they have to work with and certain guardrails that prevent them from giving certain relief. And then finally, special servicers are by and large beholden to direction from what's known as the B-piece buyer, and that's the bond investor who will suffer the first loss in the bond pool into which the loan has been sold. So, with that, Larry, what is the overall strategy in approaching a Cmbs servicer in the event of a default or a pending default?
Well, thank you, Adam. It's a pleasure to be here today. First thing is you want to be very careful what you say to a special servicer. And we will talk about that in much greater detail later. But the general overarching theme I think that any borrower would want in dealing with Cmbs is to try and stay out of special servicing as best as you can. As you mentioned, in the pooling and servicing agreement, there are certain events that will require the loan to be transferred into special servicing, in which case the special servicer becomes involved. And then there are certain processes and undertakings that the special servicer must follow under the pooling and servicing agreement once it goes into special servicing. And all of this can cost time and money to the borrower, in addition to the fact that the special servicer itself charges a monthly fee and other periodic costs to service, quote unquote, service the loan. So essentially, there's very little motivation for the special servicer to get the loan out of special servicing. And it is just in general very difficult to get a loan out of special servicing because of the costs, because of the fees, in addition to the loan fees, potential default interest that you have to deal with. So it becomes a situation where it's almost impossible to come out. So if you can restructure a loan, if you can approach a master and special servicer and do something with the loan to work it out where you don't go into special servicing, that is usually the optimal result.
So Larry, just a quick follow-up question. What is the universe of decisions a servicer, as distinguished from a special servicer, can make?
It's all dependent on the pooling and servicing agreement. And usually the terms vary, but in general, the master servicer has essentially the ministerial tasks for the loan and the pool. They can review leases, they can review what construction takes place up to a certain amount, just essentially the yes or no questions, if you will, under the loan. The special servicer has to get involved when there are much more substantial questions. And sometimes the master and the special can make the decision together. Sometimes it's only the special that makes the decision. But anything involving the economics of the loan, usually forbearance, goes involves a special servicer. And so when it's something that's more significant, usually the special servicer has to get involved.
And we all want to avoid the special servicer. But so, given the pandemic and the shutdowns, our clients that are most customer facing, shopping centers, shopping center owners, hotels, they're all shut down, right? And they're really in great risk right now. So, in taking stock of their situation, what steps should our borrower clients take to be prepared to best position themselves for loan workouts with CMBS servicers?
So the first step is to go through the loan documents very carefully and abstract the provisions. We want to pay specific attention to notice requirements that are in the loan documents. We don't want to be in a position where we're waiving any rights that we would have or triggering any potential defaults under the agreement. Oftentimes in loan agreements, there'll be requirements that the borrower provide notice to lender if there's been a material adverse change, which certainly has happened in most cases now. And if there's an event of default under the loan agreement, that's also something that usually requires notice to the lender. So we want to pay particular attention to that. Also, the non-recourse sections of the loan agreement are going to be critical here. Anything that we do, especially given the sensitivity and the potential defaults and exercise of remedies by lender, we want to make absolutely certain that we don't trigger any personal liability under the non-recourse carve-outs. Also, we want to look at the cash sweep provisions. These CMBS loan documents will have cash sweep triggers where the rent and proceeds from the property get trapped and the borrower has no control over those. And it's often hard to get out of a cash sweep. So we want to do anything we can to avoid triggering a cash sweep. And then looking at the covenants in the agreement generally. So that would be operating requirements for hotels or leasing restrictions for retail centers. We want to look to see what we can and cannot do with the tenants in negotiating loan modifications that have come out of COVID-19. Another thing to pay attention to is to avoid making any distributions. This is not a time where borrowers, in most cases, should be distributing any money out to their owners. That's something that the lender is going to look at, and they want to make sure that the revenue is being used to maintain the property and not going into the principal's pockets. Finally, having a plan. This is going to be critical in getting any loan forbearance or workout approved by a servicer or a special servicer. They want to know that the borrower's on top of things. So, looking at the status of the tenants and even looking about any viable potential replacement tenants if some of the tenants go out, or looking at travel projections for hotel loans. This is the story that we're going to tell to the servicer as to, how we're going to come out of this in the long term or even in the shorter term.
Those are all great thoughts about preparing. So my recollection, which I tried to put out of my mind from the Great Recession, was there's something called a pre-negotiation letter, which is really the next step. So Larry, what is a pre-negotiation letter, and what should concern a borrower about signing such a letter?
Well, in theory, a borrower should not be concerned with signing a pre-negotiation letter if the document is drafted for the purpose in which it was intended. The idea of a pre-negotiation letter or pre-negotiation agreement is to allow, a free exchange of ideas and to allow the parties to negotiate without a, don't hold me to it theme. The borrower and the lender want to be able to talk freely, exchange emails, exchange term sheets, and say, listen, don't hold us to this unless we have a written document that both parties have signed that they intend to be the last and final word on the negotiations. So that's what the document is intended for. It's intended to be really a shield for the lender and the borrower to make sure that both parties understand that we can talk, we can email, we could send out letters and term sheets without being held to this. But unfortunately, the document is now sometimes used as a sword by the lender. You have situations in which the document requires a restatement of the reps and warranties, or it includes a full, complete release of the lender for every action from the beginning of time till now. And that's really, number one, not what the document is intended for, but number two, from a borrower's point of view, you can't make some of those statements. If the loan's in distress, restating the reps and warranties are probably not true. That's why you're in this situation. So you're signing a document that would essentially be false. Or, releasing lender claims, you're probably releasing something that you don't even potentially know about. So for the lender to use it as a sword is, it becomes an untenable situation for the borrower. And there's a certain absurdity there of having to staunchly negotiate a pre-negotiation agreement. We're not even negotiating a loan, we're negotiating a negotiation agreement. So hopefully calmer heads can prevail, and you can reach an agreement on the negotiation agreement without putting the borrower to task.
So now we've got a loan that's gone into default or about to go into default. We've taken stock of the loan and the provisions. We've gotten through the pre-negotiation letter. So do we call up the servicer, Joel, and do we say, hey, we can't pay? What happens then? I mean, what should we say to a servicer?
Right. So it seems a little counterintuitive, given the current circumstances and what we're talking about with the lender right now. But we want to avoid any admissions of inability to pay our debts as they become due. One of the central themes in the CMBS loan documents is the avoidance of bankruptcy. So any admission of insolvency, could trigger certain provisions under the loan documents. So that's something that we want to avoid when talking to the servicers. Also, we don't want to admit any defaults. We should always talk about it in terms of potential defaults. And not admit any defaults. And if there are defaults, then we should limit it to the specific defaults rather than, talking more generally about other defaults that could be triggered under the loan agreement. Again, because we want to avoid getting the loan transferred into special servicing and be talking about these circumstances in terms of performing loan consent instead of a special servicing default situation.
Which brings up sort of another issue, which is borrowers, particularly in the shopping center context, are required to comply with their loan covenants. One of the covenants being enforce your leases, right, and ensure your tenants are paying and operating. But at the same time, these days, obviously, borrowers don't want to throw tenants off their properties because they need tenants once they come out of this thing. So what's a borrower to do? Do borrowers just enforce the leases willy-nilly and throw the tenants out, or how do they do this?
Hopefully not. As most know, it is difficult to replace a tenant. The brokerage fees, the tenant improvements, you want to keep tenants there. Just for optics purposes, you have a shopping center, you want to have operating businesses. We've all heard about these zombie centers. You want to try to avoid that at all costs. But as it specifically relates to the rents and to the leases, you have to review your loan documents. You have to make sure that you're complying staunchly with the covenants. You want to not talk about rent forgiveness. You want to talk about rent deferral. And I think another point that somebody loses, you also want to be mindful that the lender's collateral are the leases and are the rents as well. And so if you're talking to a tenant about negotiating a rent deferral, it will probably be much more palatable to the lender if that rent is still seen period of time before the maturity of the loan. In other words, the lender's still getting that rent. It's just not getting it in the time that it expected to get it, but it's certainly getting that rent, hopefully, before the maturity of the loan.
Larry, just a follow-up. So money's coming in, a little bit anyway. but not enough to comply fully with the loan. So what do you do in terms of prioritizing what you pay? Do you pay your mortgage? Do you pay your property manager? Do you pay contractors? Where's the line?
It becomes difficult because you have all these people with hands out, and when you get into a distressed situation, rent's not coming in, it's tough to see who to pay. The first thing is always be mindful of your solvency requirements. As Joe mentioned, resist making that distribution. If the solvency is a strange concept, and if the borrower had any notion that a tenant was going into default and then makes that distribution, you don't want that to show up on a complaint filed by the lender that they allege that you knew of this and then made the distribution and therefore made the entity insolvent. But just in general, the hierarchy should be first is pay your taxes. The payment of real estate taxes or lack thereof is prima facie evidence of waste, and a number of your loan covenants are probably in violation if you don't pay real estate taxes. And then secondly, while it depends from jurisdiction to jurisdiction on who can file a lien, you want to make sure that the parties who can file a lien are paid as well, because again, a lien will also trigger a number of loan covenants and loan defaults. And so, the guy doing the girl doing the maintenance on the property, probably can't file a lien, but the person replacing your roof probably can file a lien. And so unfortunately, you have to get a hierarchy of who you can and cannot pay, and tough choices need to be made, and the person who can file a lien or has lien rights should probably be paid.
That's all great advice. As we wrap up, Joel, do we have general advice for borrowers who are in distress, sort of 10,000-foot advice?
The first thing is you want to, not delay in providing any notice and engage the servicers as soon as you can. Again, as we mentioned, we don't want to be waiving any rights or tripping any defaults under the loan documents. And we want to demonstrate that we are on top of the situation and that we have developed a plan to promote long-term success, and that this is just a temporary event, and the forbearance that we're requesting or the workout that we're talking to them about is something that is achievable and that is in the best long-term view of the property and can protect the collateral for the loan, and that's the best way to get the lenders and servicers approval.
So Larry, any nuggets of advice from the 10,000-foot level you'd give?
Well, first, those non-recourse carve-outs, they're very, very important. Read them scrupulously, read them in the best light of the lender and in the most conservative meaning against the borrower, and act accordingly. And also just, be mindful that the borrower is walking a tightrope, as Joe mentioned, of, telling the lender, I'm in trouble, or I'm about to be in trouble, or I could use some relief here, but yet assuring the lender that I am fully capable of paying my debts and I'm not insolvent. So it's just very, very difficult, the tightrope that you have to walk to ask for help, but yet not make any unwanted or unneeded admissions that provide unintended consequences under your loan documents.
All great advice, guys. So let's hope this workout season does not last long and our clients can get back to making productive deals. For more information on our law firm, please visit www.honigman.com. Join us next time when Coffee and Counsel will examine real estate tax appeals. Until then, this is Adam Rothstein saying, wash your hands and wear your face mask, and have a great day.